Hello, welcome to the webinar, and thank you for joining us. I am thrilled here to have Brad Barth, our speaker. Before we get started, though, I do want to just point out a couple of things. One is, for those of you who've been on these webinars, you know we always send you the recording. I was just talking to Brad right before this, and Brad says this is going to be a packed hour of information.
Yeah.
So you can't write it all down. You can't remember it all. It's okay. It's going to be sent to you. And Brad will probably share the slides with me too. So don't worry about that. And for those of you who don't know Brad yet, he's been with us a few times now. Now he's a regular with us
Thank you.
on matters of estate planning now for this topic, but he's also done some asset protection and some information about coronavirus as well when we really needed that information. So thank you so much, Brad, for coming on today. I'm really thrilled to have you, especially because we haven't covered this topic ever. And I think it's extremely important. And it came up in our coronavirus discussions. A lot of people are looking at their estate planning now. And I think it is a good time to look at it and review it. And you have a lot of knowledge that we can tap into specifically for rental owners. So one last thing before I hand it off to you, Brad, for those of you on the call who have questions, I'm sure there will be many, go ahead and put it in the question and answer box so that I can ask those to Brad after he's done. It is going to be about an hour, and then we're going to do Q&A. So try to stick around as long as you can and put in your questions when you have them, and we'll review them at the end. So with that being said, take it away, Brad.
Great, Alexandra, thank you very much. And it certainly is a pleasure to be back here with the American Apartment Owners Association. And yeah, this came up. We were doing a conversation, a webinar regarding landlord issues and COVID matters. And I said, well, this is a definite wonderful segue into doing a talk on estate planning. So Alexandra worked with my office and we kind of got this on tap here. So one of the things that I find is relevant when it comes to estate planning is to understand at least who you're talking to and what's the perspective that I bring to estate planning. I've been doing this work for about 22 years, and I got my start as an estate planner. And then I kind of moved and I kind of advanced through those areas where I wound up doing trust and estates administration. And that basically is when somebody passes away or somebody becomes incapacitated, somebody has to pick up the documents that you drafted and actually implement them. I'd say that's where the rubber meets the road. So I have a lot of experience in the administration side. I also deal with litigation. So when the kids are fighting about inheritances, or they're fighting about the piano, or you're fighting about a fiduciary, a trustee who's not being all that friendly, I also do the litigation side of trust and estates. And then lastly, I'm also a professional trustee. And so for those that have either nobody in the family that they really kind of trust to do the job, or they're just concerned about creating a civil war among the kids or siblings, then they want kind of like a neutral third party, somebody who understands what the responsibilities are. I also serve in that capacity. So when I give my talks about estate planning, I'm not just sitting here philosophizing about who should get your stuff when you pass away. I come to this from a very practical point of view, from a drafting, administration, litigation, and from a trustee's perspective. So I think what I deliver in these types of presentations are not the what can I do through my estate planning, because you can pick up any book about that, but moreover the what should I do, right? The coulds versus the shoulds is a big difference between, I think, working with an experienced planner and working with one who basically may not be as familiar with this area. So I kind of have a subtopic here called protecting and enhancing your legacy. And I kind of shrunk this presentation down to specifically address some of the real estate matters. So let's take a look at what's on the agenda for today. All right, so I went ahead and just talked about the need for estate planning, some of the benefits and scope. We'll talk about probate, especially for those of us that have real estate. Probate is going to be a really, really big deal. And of course, I'll be giving you planning tips throughout the course of the hour. Again, you can't talk about estate planning without talking about taxes. They say there's two certainties in life, death and taxes, and that's kind of what we're talking about. So what is the impact of the Trump tax cuts that became effective of January 1, 2018? That's also a very important date that we note, because we have people that have drafted plans before 2018, and you'll see what type of changes may be effective as a result of that. We'll talk about some estate tax reduction techniques for those of us that do have large estates, either under the current Trump administration laws or what may happen in the future with a reduced estate tax exemption. Also with state death tax issues. Although I'm coming here from California, we do not have a state death tax, so I may not be familiar with all your individual state laws. So I'll be addressing the estate tax things from a federal level only. And also some recent developments and how that affects what are called inherited IRAs. And there was a question that kind of came up about the use of IRA-owned LLCs. That's kind of beyond the scope of an estate planning talk, but I certainly will address the use of an IRA-owned LLC within the inherited IRA environment. And also with the new Secure Act and how that affects your retirement plans and what we used to be able to do as far as stretching out retirement plans, what do we now have to look at with regard to that type of planning? And then lastly, I always find it to be a responsibility of an advisor to always talk about charitable planning. And I think I'm only going to be talking about one of the tools. And I find I'm using this tool specifically because it's the tool that is most relevant to my property owners. And that's the use of a charitable remainder trust. Hopefully we'll be able to squeeze all this stuff in the next 55 minutes. So let's go ahead and get started. So I always want to start off with a definition. It's very important that we all acknowledge and know what it is that we're talking about. How can you talk about estate planning unless you know what comprises your estate? Most of us as business owners or as property owners have put together a personal financial statement for the benefit of a bank or for getting a line of credit or some business transaction. And so we're very familiar with like our house and real estate being part of our net estate, or our stock and business owners, or our personal property, and certainly our retirement assets. And also on a personal financial statement, you'll see the cash value component of a life insurance policy. But what typically is not listed is the death benefit value of a life insurance policy. So you can have a net worth of, let's say, $3 or $4 million, and then you have a $3 or $4 million death benefit of a life insurance policy. So for estate tax purposes, the estate is not 3 or 4 million. The estate is either 6 or 8 million, depending upon the numbers that we're using. In other words, the death benefit is included in the value of the estate for estate tax calculation purposes. And why is that important? Because whenever I speak with my clients, they're always saying that, well, I thought that the life insurance is tax-free. It's income tax-free to the beneficiary, but it's included in the estate of the owner. And that's very important because although we're currently enjoying a very large estate tax exemption under the current Trump administration, we don't know what's going to happen in the future, whether it's going to be next year with a new administration or after a certain date of January 1st, 2026, and how the laws may change. So although you may not have an estate tax problem now, even with your insurances, you may have it in the future. So I want to make sure that you understand that inclusive of the estate for tax purposes is the death benefit value of a life insurance policy. And for a lot of my clients, that comprises the largest asset. They may have, their house may have a lien against it, a mortgage against it. They may have some money tied up in retirement, but they have millions of dollars of life insurance. So just make sure that you remember that that's part of your taxable estate. So one thing also when it comes to real property owners, you got to know what probate is. And you always hear, have an estate plan and avoid probate. They talk about probate like it's some kind of 4-letter word. And the reasons why you want to avoid probate is primarily because of its lack of privacy. It's like any other type of court proceeding. It's completely available to see, who's getting what upon somebody's passing. And also just the time and expense that's involved in it. And every state is different. And one of the benefits of having traveled the majority of the states in the country, having given these types of talks, is that I know that states like California, estate planning is probate is very, very expensive because we go based upon percentages of gross estate. Whereas other places like Texas, for example, it's actually pretty inexpensive, mostly based upon or attorney's hourly rate. So there's a big variation between the cost of probates, but generally speaking, most people try to avoid probate, if not for the cost, certainly for the privacy. Because what we're always worried about is that there are unscrupulous people out there that want to sell assets, sell investments, sell real estate investments, or want to work with your beneficiaries, they just find out that little Johnny just inherited $2 or $3 million. And little Johnny may not have the financial maturity as to how to manage that $2 or $3 million. And I know this is a matter of fact because I, as the fiduciary, wind up receiving a lot of this correspondence from those folks out there, because they're going on the public records and finding this information. So we want to make sure that we use probate as a protective privacy tool, so we're able to kind of like keep those types of, I call financial predators, away from our newfound wealth with our beneficiaries. But also, very importantly, when it comes to real property owners, is what's called an ancillary probate. So not only do you have the time and expense associated with probate in your own state, every other state where you own real estate, which is very relevant to our conversation here. I'm in California. If I own property in Nevada, Florida, Texas, and I pass away, well, guess what? I'm going to have a probate here in California. Now, California can only control the dirt within California's borders. So how do I then deal with Florida or Texas? Or in Nevada? Well, a California judge cannot control what happens in these other states. So you have to have another probate called an ancillary probate in all those other states. In my example, Florida, Texas, and Nevada, at the time and expenses associated with that state's probate rules. And I always give the example that probably one of the most complicated and most expensive probates I ever had to deal with was with a lady that passed away in Arizona. Their estate was wrapped up pretty quickly in Arizona, probably within 6 months or so, but she happened to have owned 13 parcels of property in Riverside, San Bernardino, and LA County. That took 3.5 years at my attorney's rate under the California rules in order to do a full administration. Very expensive and completely avoidable if she would have used a proper estate planning tool called a trust. And so some people say, well, I don't need to worry about probate, Brad. I have a will. And what's misunderstood about that is that although a will is an estate planning tool, it is not a probate avoidance tool. As a matter of fact, the only proper officer to actually read and implement a will is the probate court. So when you basically go to probate, it is proving up the will, that it was properly executed, et cetera, et cetera. So it's not a probate avoidance tool at all. It's actually a guaranteed admission ticket to probate. Well, then I get things like, well, my will creates a trust. So you're talking about trust. Well, my will creates a trust. I've nominated successor trustees. I appointed the beneficiaries. I gave all these separate provisions from it. Well, you've created what's called a testamentary trust that's arising up through a will. Well, if you took the time, effort, and energy to create it in a will environment, why not create it during your lifetime, fund it during your lifetime, given the option to continue to make changes during your lifetime, and completely avoid the court's assistance in creating that ultimate testamentary trust? So just again, one of those things that comes across a lot of times, I want to make sure that's addressed, that having a will by itself is not a probate avoidance tool. There are other forms of assets, however, that do avoid probate, and one of them happens to be joint tenancy. So there is a way of transferring assets without the need of an estate plan, without the need to go into probate. And things like joint tenancy, life insurance policies, retirement plans. Like joint tenancy, those assets go by whose name is on title of the deed. I call it whoever lives the longest gets the asset. It has what's called the right of survivorship. Things like life insurance policies and retirement plans, these have listed named beneficiaries. And so long as there is a named beneficiary and it's not the estate, whomever's listed as the beneficiary, they're the ones who are going to get the asset. So let's kind of explore this for just a moment. So joint tenancy typically is held between husband and wives in non-community property states. It's typically held between business partners, between siblings, between parent-child. And it's not only relevant to real estate. You can have assets that are held, bank accounts that are held in joint tenancy, for example. But the important and unique thing about joint tenancy is this bullet point right here called a right of survivorship. It's very simple. If you have two people who own a piece of property, and one person passes away, the asset vests automatically in the surviving joint tenant. It's not that the deceased joint owner's interest is inheritable or divisible down to their beneficiaries. No, it goes to the surviving joint tenant. That's what's called a right of survivorship. And so what happens here is that we wind up having unintended disinheritances. And I see this all the time. A couple of business people, siblings, they go ahead and they invest in a piece of property. They each put in $100,000. So their initial contribution is $100,000. The property then appreciates up to $1 million. And they're sitting here saying that, thank goodness, because if I ever were to pass away, I know that my family is going to have the income and the future appreciation or whatever of this particular asset. Unbeknownst to them, they went ahead and signed the deed as a joint tenant for whatever reason. It could be the advice from counsel, maybe the notary who came, gave them that particular advice without fully appreciating what just happened. So now when the first deceased joint owner passes away, the surviving joint owner files a piece of paper. It's called an affidavit of death of joint tenant. And when they file that, the property then vests in the surviving joint owner 100%. In this case, it's 50-50. If it's a third, then you just get whoever lives the longest gets it. And they have no obligation to give anything over to the deceased co-owner. Basically, you have that unintended disinheritance, which winds up being a disaster. We do use joint tenancy, don't get me wrong, but it has to be used purposefully and with intent. So here, a very simple estate plan. I have a good friend of mine who's a client, and he says, listen, Brad, my mom, she came here to California I'm the only son. She came here to be closer to the grandchildren. She has a house and she has a small bank account that she's receiving Social Security on. Do I have to go through all of this of having an estate plan, et cetera? And his name is Darren. I said, Darren, the answer is no. We can just go ahead and put the mom's bank account in joint tenancy, put mom's property in joint tenancy, assuming mom passes away before you. All those assets simply vest over to you, and it's a one and done. Basically, it is an effective means of transferring assets without the need for a full estate plan. I also recommend these things as an administrative side pot. So what I mean by that is I just got done telling you that I'm a trustee. Well, as a trustee, I'm responsible not only for managing the assets of the trust and keeping those assets productive and protected for the benefit of the beneficiaries, I'm also responsible for all the liabilities, paying off the debts, the tax liabilities, etc. So you can assume that absent I getting a full inventory and appraisal of all the assets and all the liabilities, I'm not letting a single dollar out of my hands to the beneficiaries until I know I have a liquid estate. Because if I start slinging money to all the beneficiaries and then there's a tax bill, I become personally responsible for that tax bill. And it's going to be very difficult to go collect money from the beneficiaries once that money has been distributed, because typically it doesn't last very long in their possession. So I hold on the assets and don't make any early distributions until I've determined I have a liquid estate. And that could take 6 months, it could take 18 months. So sometimes knowing that we may have this type of challenge, we go ahead and say, let's take $50,000 and put it inside a joint account with the good son, let's just say. So while we're trying to figure out the administration, there's an immediate amount of money available to one of the kids, for example, to take care of final expenses, funeral expenses, hiring the lawyer, things of that nature. So we do, again, use it as an administrative side pot. We also use it in blended family scenarios or special beneficiaries. Sometimes you just don't, there are other reasons why you simply wouldn't want to have a child listed in the plan. Maybe it's a child that from a previous marriage that nobody knows about, for example. So you may want to have some way of transferring money over to them without them being listed in the actual estate plan. Again, there's different reasons for it, but again, it's another reason why we may use joint tenancy. So we're worried about is these bullet points in red. Unintended disinheritances happens all the time. Unintended liability exposure, because again, as a joint owner, you own the assets 100% each in two people. You both have a 100% use and enjoyment of the property, even though it may be the income and liabilities may flow 50-50. And consequently, which means that the creditors of one joint owner can completely capitalize on the asset, and the innocent co-owner could actually lose their investment. So not only is it bad from an estate planning point of view, it's also bad from an asset protection point of view, which was a subject matter of our previous discussion. There also can be some unintended gift tax consequences when you're actually creating a joint tenancy. Well, you've actually given an asset away over to a third party, whether family members or otherwise, and that could trigger some gift tax consequences if that dollar value exceeded $15,000, that is as of the year 2020. And then one of the things that we use, which is a big takeaway from all this, is an LLC holding company. Again, from the previous discussions that we had, LLCs really are the primary ways of holding rental properties, sometimes residences, sometimes not, depending upon how it's structured, but typically for rental properties. And inside the LLC operating agreement or in the limited partnership agreement, we have ways of transferring those interests as divisible interests or to be recaptured as far as a right of first refusal within the other co-owners of that LLC or that limited partnership. And not only is it good from a liability point of view, also from an asset protection point of view, and from an estate planning point of view. So definitely the proper way to do it. Joint tenancy, like I said, it's good, it's effective, but it could be very dangerous if it's not used correctly. The other form of will substitute has to do with contracts, and this goes back to my life insurance policies and my retirement plans. And this always a big trap for the unwary, simply because whoever's listed as the beneficiary, they're the ones who are going to receive the assets. It doesn't matter what your estate plan says. And I use a very simple example on this. That if basically you have an estate plan that says to my three kids, a third, a third, a third. And this say it's a second marriage, for example, to kind of make it real. This is actually a real situation I dealt with. And on the life insurance policy, they actually listed the former spouse. Let's say it was Marianne. Marianne was the actual beneficiary listed. Well, that relationship dissolved. They started up a new family and then new wife and new children. And they never updated the insurance policy. And they're all moving along, assuming that should I pass away, of course, I got this $1 million of assets going to pour in for the benefit of my surviving, my now spouse and my kids. Well, the owner passes away, and guess who got the insurance policy? The money. The money went up to Marianne. It didn't matter that the plan said to my three kids, a third, a third, a third, because now you had an asset that was inconsistent. It was going this way rather than this way because the assets and the planning were simply not talking to each other. And the same thing applies over with retirement assets. Again, my biggest offenders here, this happens to be school teachers. I think it's just because when they get out of college, they join the teachers union, they sign up for the 403B plan, they list mom as number one beneficiary. If not, they list their sister as a contingent beneficiary. And then they spend 30 years educating our children, and then they pass away. Now they're married and they have their own children. And all of a sudden, when they pass away, who is the listed number one beneficiary? Mom. Mom is predeceased. Number two is the sister. And the sister, in this case, was a bankrupt drunk and she hates her brother-in-law. So here again, another example where the retirement funds went off to a different direction and left the spouse and surviving children without the use of those funds simply because the contract said one thing and the estate plan said something else. And so I always say when I give these estate planning talks, if you get one thing out of this entire talk for the next hour, go back and look at the beneficiaries of your life insurance policies and look at the beneficiaries of your retirement plans. Because most of my clients have three categories of large assets: their residence, life insurance policies, and retirement plans. And you want to make sure that those assets they're jiving with your estate plan. You want the beneficiaries done correctly, and then also the real estate as well. So again, very, very important that the assets and the planning are talking to each other. So here again, another example of an unintended disinheritance. So the need for estate planning that we look to find the financial burdens that can be solved, settlement issues, okay, as far as probate fees, again, that varies based upon state, attorney's fees associated with that, estate taxes, that's gonna be something we're gonna talk about. And then we have to worry about improperly arranged estates. So you have insufficient liquidity, and this is going to be a big deal with our property-related expenses. Unintended disinheritance, we just kind of spoke about that a little bit. Unintended trust fund babies, simply create this dumping a whole bunch of cash onto somebody who doesn't have the financial maturity really to deal with it. They didn't have to earn it and don't really respect what it provides for them. And then based upon their age or their influences, that money could be used to their disadvantage. But regarding property-related expenses, let me go ahead and just address that, because we are talking to a property owner group, and this comes up a lot where there's the parents want to leave a legacy property or an apartment property or an investment property over to their kids, but the kids not understanding that the kids themselves may not want it. Or as a result of that transfer, there may be new expenses or taxes associated with that property that the kids simply can't afford to do. And so as a result, you have insufficient liquidity on how to deal with those legacy assets. You're forcing a buyout between sibling and sibling. That may cause its own set of issues, or you may wind up just having a sale or a fire sale of an asset, which really wasn't what you intended. So you want to make sure that when you're planning with real estate and you tend that real estate to go down in successive generations, you want to make sure we have sufficient liquidity to pay for taxes and expenses and utilities of those assets as well. Again, another very important factor for real estate owners. Now, it's kind of crossing over to the COVID issues. This has become one of the hottest topics right now, at least in my office, and this is dealing with powers of attorney for healthcare and property management. These are dealing with documents of incapacity. And over 20 years, I always go down and say that these documents, the powers of attorney for healthcare and property management, are the Rodney Dangerfield of estate plan documents, simply because they get no respect. Everyone's always worried about who gets my stuff when I pass away. Everyone's always worried about the guardians. All that stuff is very important, but they're all thinking about post-mortem transactions. But what I always want to tell my clients is that don't forget that the big part of this planning is also for your benefit. Who takes care of you if you can't take care of yourself? So getting back to what I said earlier, sometimes your estate planning, your administration may take 6 months, it may take 18 months before you actually have a netting out of the estate, setting up some big accounts, and it's kind of on autopilot for the beneficiaries. But if you get into a car accident, God forbid, now all of a sudden you become incapacitated. You may be incapacitated not for 18 months, but for 18 years. And who makes decisions for you? No one's passed away yet, so there's no assets being transferred to the next beneficiaries. The question is now, who steps in your shoes and makes decisions for you? So you have to look at it from a property management perspective, and you have to look at it from a healthcare perspective. And property management is becoming a really big deal. So not only is it, I look at elderly parents, that's always one of the things that we worry about, because I get calls every once in a while and says, Brad, my mom is in a care facility, and she's getting demands from this new relationship. She wants to start sharing money or paying the bills of her newfound friend. And so we're always worried about how are we able to protect an elderly parent from themselves without the need to go into a conservatorship, without the need for the embarrassment, the public exposure of these types of issues, worrying about hoarding problems, undue influence issues. We want to be able to step in the shoes of our parents and be able to take care of things for them without basically requiring them to go through all of these legal procedures of getting a conservatorship put over them. Impact on business, that's huge. And that kind of ties into my next point as far as a limited power of attorney regarding COVID issues. So I always like to use myself as an example here. I know, my wife and I, she's great for everything, right? She takes care of the bills and she helps pay for the taxes, and she manages the household finances, and she makes sure that the investments are going well. But she doesn't know the first darn thing about running a law firm. My father, who's actually my partner of the firm, well, of course, if I become incapacitated, the best person to make decisions regarding the law firm is not my wife, but it's going to be my father. But I don't want my father involved in my daily activities of managing my finances and my retirement planning and filing my taxes. So when you have a general power of attorney, it applies not only to all of your normal mundane assets, but typically also accounts for any business interest that you own. And so sometimes you may want to carve out a limited power of attorney for a particular asset. And again, in my case, a limited power of attorney regarding Barth Calderon. If not Brad, then Harry Barth, my dad. But the general power is everything else as my wife, excluding Barth Calderon. So I also have one with my dad. Like right now, my dad, he's 73 years old, and thank God he's healthy, but he basically is self-quarantined. He's one of these high-risk individuals, and my father hasn't left the house in 4 months. So who do you think is doing the banking on his behalf? Who do you think is negotiating with the landlord at the lease on his behalf? It's not him, it's me. And I'm doing this by way of a limited power of attorney on behalf of not only my dad on the personal banking side, but also on behalf of Barth Calderon. So another example where a business partner is the best person to manage a particular asset, especially in this type of environment where my mom is the one that's taking care of all the everyday finances and retirement plannings and investments and paying the electric bills, et cetera. I don't need to get involved in that. Let them, I will take care of the one asset. And this is becoming a really big deal in light of COVID because everyone is kind of self-quarantining. Also, in the same vein, if you're incapacitated, who's going to make medical decisions for you? You know, here in California, we call it an advanced healthcare directive. It includes a very important provision that not only nominating individuals to make medical decisions for you, but there could come a point in time where you say, well, I don't want to receive medical care, right? If I'm in a medically determined irreversible coma, I'm effectively in a permanent vegetative state, and all you're doing is kind of artificially delaying the moment of my passing by keeping me plugged into these machines, which is causing economic hardships. It's causing emotional hardships. Some people, well, the majority of people, under those circumstances say, listen, remove the intervention. Let my body do what it's going to do. However, I still want to receive enough medical care for my comfort and to alleviate pain. Call it the companions. Let me go, but don't let me feel it. You got to put that stuff in writing. We have to have clear and convincing evidence. So in other states, it's called a living will. Don't confuse it with a last will. A last will and testament is different than a living will. A living will is what we refer to as the pull the plug provision. Very important provision. If you ever want to see the circus, just look up the old case of Terry Schiavo back in Florida, and that will kind of bring back nightmares for some of us. We also want to address your final wishes and arrangements. You know, what about making anatomical gifts, for example? You know, so if you are an organ donor, and people have, like here in California, we put a little pink dot on our driver's license. When I normally ask the next question about being an organ donor, says, well, does that mean that you also want to be a teaching cadaver at the local medical school, or do you want to help humanity by donating your body to science? That's being an organ donor. They're like, nah, what I intended was if I help another human being directly, like someone needs a liver, you know, or a heart, I'm okay with that as a human being directly, but I really didn't intend for institutional beneficiaries. Okay, well, let's say so. Let's go ahead and put that direction inside there so the agent knows how, because typically at that point in time, it's very difficult to have a conversation. What did you mean when you said organ donation? Also regarding final wishes and arrangements, for some people, it's burials versus cremations. There's religious issues. There's certain places. There's certain people they want to acknowledge. So you want to make sure this stuff is all kind of written up inside the documentation, because you want to give people notice and instructions on what you want to have happen. And also a very important deal here is also with the long-term care provisions, because I find that this is missing from a lot of documentation. And one of the great things about here in California, that we actually have very good documents in this regard. And probably about 2007 and 2008, our government went to work and came up with some very good provisions regarding long-term care. And so here, a basic statement should be said that if I require long-term care, and if that care can be delivered to me at home, it's my preference to stay home, have that care delivered to me as long as it can be done without endangering my mental or physical safety. Okay. And if I do require care, I want to be in a facility that's the least restrictive. It's the most home-like setting. It's close to friends and family. It has outdoor activities. I want to return home as soon as possible, right? You got to put this stuff in writing. Otherwise, you literally can have someone just putting you in a home and kind of forgetting about you. And I've seen this where the kids are more concerned about protecting and preserving their inheritance. They're not putting a lot of dollars into the care of mom and dad. It's very sad. You want to make sure you have some documentation that kind of spells out what you want, so we have a way of enforcing what those provisions are. Again, very, very important documents. The next one, of course, is with us that have minor children. I have a couple of minor kids. I have 4 kids. I have 2 adults. I have 2 minors. And so here, this is probably one of the most important decisions that most people need to make. And my oldest daughter is 21 years old. And my youngest right now is 6. And my wife and I, for 22 years, have been arguing about who the guardian should be, because we're concerned. I mean, who better to raise your kids than you? And it's difficult because it's not just, oh, my sister. Because along with your sister comes your brother-in-law, right? Love your sister, brother-in-law, not so much, right? But you have to worry about putting your children into somebody else's household. Do they share the same type of socioeconomics that you're trying to raise your kids in? I can tell you, over the years, I've moved into different cities to create a better environment and better school districts for my kids to be able to grow up in. Religious issues. I'm a religious guy. I have my kids in religious school. I'm involved in the religious community. So the people that I choose for guardians are important, that they also have similar type of religious foundation. So that's important also. In-law issues, I call it outlaw issues. You know, like I said, love my sister, my brother-in-law, whatever, or I love my brother-in-law, I don't love my sister so much. So it's important on who the best person is, and geographical issues is another big deal. You know, you have children that are growing up in a certain environment, and they're involved in the community, they're involved with the church, they're involved with the Boys and Girl Scouts, and they have their school friends, and all of a sudden something happens to mom and dad. And I've seen this, where they're picked up and they're moved to different countries. They're picked up and they're moved across the country. And all of a sudden they lose their social structure, their entire support system. And now they're put into some strange environment because, oh, just my sister should be the right one. Sometimes the guardian may be your best friend. It's the person that you hang out with on a regular basis. So give that some thought, a very, very big deal. And not to mention the economic hardships. As I said, I have 4 kids. They're already an economic hardship on me now. But if I take my kids and plop them into somebody else's house, it's certainly going to be an economic hardship on them as well. So I don't want my guardian simply to say no, because I can't afford, thanks but no thanks, I can't afford to take care of your kids. So I got to make sure I have enough liquidity in my estate to be able to provide for them. I want you to have custody and guardianship over my kids. I don't expect you to pay for my kids. I will pay for my kids. That's my responsibility, either by way of having the assets in your estate or manufacturing the assets by having an appropriate life insurance policy or policies. And who do you manage to do all this stuff? Again, who do you trust? And again, I'll use my sister. I'll give my sister my kids, but I won't give her my checkbook, right? And so I call my sister the golden heart and the empty head. Love her. She's a great person, but she's terrible with money. So here I may wind up giving somebody else to be the financial guardian, my father, for example, but then I give my sister will have physical custody of my children, because again, she's probably the most appropriate age. I think my dad at 73 and my mom at 73 are not really to take on a 13-year-old and a 6-year-old at this point in their life. They were my guardians at one point. They're not now. One of the benefits of having an estate plan while you're alive is that it's transitory. It can completely be changed and modified during your lifetime. Guardians, healthcare agents, people making decisions regarding your finances, when you wind up putting people on as fiduciaries, especially in the guardians, you wind up looking at them from a very different perspective. We've had different guardians throughout the years. And when you notice somebody and you go to visit their home and you're there for a weekend, you're like, maybe we should reconsider this choice, because look how they're raising their kids. Not quite what we had in mind. So again, you start looking at people differently, but if you don't have the documents, you're just simply relying on the state documents to appoint someone, or they'll figure out amongst themselves, it may not be the best choice that you would have chosen or had an opportunity to kind of look at it from that perspective. So it's an important thing to take into consideration. And how are all these issues resolved? A lot of them are resolved with the use of a living trust. It helps to control distribution. Now we can manage fees and taxes, very much different than a probate. We can have professional management, which prevents that trust fund babies and other types of inappropriate use of the funds. And then here we can avoid probate. How does a trust avoid probate? You hear this all the time. Have a trust, avoid probate. The question is, how does it happen? It happens by having all the assets funneling in or properly titled in the name of the trust. And so here, by the trust, I always say, is just think of it as an empty shoebox. And that shoebox is empty until you put stuff in it. When you put stuff in the shoebox, you've already determined who the beneficiary of that shoebox is. You've already listed the successor trustees. You already legally empowered someone to have custody of the assets, manage the assets, and then to distribute the assets to the beneficiaries. We don't need the state to do anything. We don't need probate. You've already affirmatively done that, and you empowered them through the legal document to do so. That's called the trust. But you got to put the assets inside. And so part of the recurring housekeeping, and why this is a very important slide, is that people will come to me in 2020, will create their trust, will fill up their shoebox with their house, their business, their bank accounts, their life insurance, retirement, will do all the appropriate funding. Then 3 or 4 years goes by. Well, they sold the house and bought a new house in joint tenancy. They closed up the account and opened up a new account at the credit union, name it in their individual name. They switched over broker. They have a new retirement plan listing somebody else as the beneficiary. Maybe they got a new life insurance policy and they listed their spouse directly as the beneficiary. And at the end of all that, what's inside the shoebox? Nothing. So although we took all the time to create asset protection provisions, multi-generational provisions, charitable considerations, it has no assets because everything else is flying in these different directions because there's nothing inside the box. And to boot, we're going to have a probate. But if the trust is properly funded, we minimize probate expenses, not only in your home state, but again, in every other state where you own property. So back to my earlier example, I have a California trust. My house that I'm sitting in is inside my trust. My property in Nevada, inside my California trust. My Florida property, inside my California trust. My Texas property, inside my California trust. So now when I pass away, I don't have any ancillary probates in those states and no probate here in California. It makes the funds immediately available. I'm not waiting for courts, especially in this COVID environment. Who knows how long it's going to take for the backlog for people to get through the whole probate process. In the meantime, there could be all kinds of needs and businesses and decisions have to be made, and it's all tied up in probate. I can give you nightmare story after nightmare story of things that happened in probate and the disasters that it's caused from a business point of view and the children needing money point of view. But again, beyond the scope of today's talk, and you also get to minimize your attorney's fees and your executor's fees. You're still going to have accounting issues and appraisals. There's still a cost associated with administration, but you certainly minimized it a lot. Now, let's talk about some taxes. This is the other part of the death and taxes. Now here, President Trump signed back in December 22nd of 2017, the Tax Cuts and Jobs Act that became effective 1/1/18. And what is the bottom line on that? The bottom line for most people is this, is that the personal estate tax exemption is now, as of 2020, $11.58 million per person. And then every dollar above that is set at 40%. So now this is on your net estate. So again, this is why estate taxes really isn't an issue for the majority of Americans, because not everybody has 11.5 million at an individual level. And if you're married, the second bullet point is that any amount that one spouse doesn't use, the first spouse to pass away of their 11.5 million, gets ported over to the surviving spouse. So you take 11.5 and you add 11.5, you got $23 million for majority of married couples in the country. And so here again, it's not big of an issue for most people. But business owners and property owners, and now you start chunking in some life insurance, now you may breach that 11.5 at an individual basis or the $23 million at a married basis. And once you breach that threshold, the tax rate is 40%. Now, as I mentioned earlier, there may be additional state tax rates that are different. Maybe there's a smaller exemption amount. Maybe there's a different amount that's paid on top of that. I'm only talking about federal estate taxes for purposes of this presentation. So here you have to be aware of this, because what may happen in future administrations is that $11.5 million exemption may drop down. As a matter of fact, look what I have in red. The Trump law is automatically set to expire as of 1/1/26. So although he was able to bump it up to 11.5, effectively doubling the Obama exemption, he wasn't able to make it permanent. And so here you have two parallel systems going on. You have a Obama level here that's being adjusted for inflation and the Trump numbers. And when Trump just goes away, it now just reverts back to the Obama numbers. And what's the Obama numbers? Roughly about $5.5 million. So you're going from an $11.5 million per person to a $5.5 million per person. And everything above that is going to be subject to 40%. And I've seen commentary from my colleagues where it may get dropped down to $3.5 million and not 40% above, 65% tax above that. So they're going to reduce the threshold and then meddle with the actual percentages above that. And I say to myself, well, look what's happening with the government printing money in this COVID environment. Some way they have to get that money back. And I always say that dead people don't vote. And this is just one of those areas where the government is able to go in and grab money from people because people aren't paying attention to this. They're all worried about the income tax benefits, and they're not paying attention to is what the estate tax implications are. So right now we have a wonderful estate exemption, and we have a great opportunity to do a lot of planning to get assets out while we have this $11 or $23 million corridor, so that if the exemption amount is reduced, you've already got the assets out. We call that estate freezing techniques. How do we get assets out so your estate doesn't just continue to accumulate, because the larger your estate, the more taxes that you're going to have to pay. And so we always take a look at that. And so a lot of our clients back pre-2018 would have what's called an AB trust. I'm not going to get into the details just for time purposes, but what we're seeing a lot of nowadays between married couples, same biological children, long-term marriages, that they're modifying what's called an AB to an A only. And I'm sorry for the technical language here. So just for time purposes, they're simplifying what the surviving spouse is able to use and enjoy without the need for separate accountings and irrevocabilities and separate tax returns, and keeping what most people would think. When one spouse passes away, it's just held for the benefit of the surviving spouse. We still use AB trusts for asset protection reasons. We still use AB trusts for purposes of highly appreciating assets. So we still use that, but for the majority of people, we go back and we take a look at whether or not an AB split is necessary. And here again, we also use it in cases of blended families. So if you do have a blended family, which now is representing about 50% of my client base, well, what you're saying is that I have a child, I love my kids and she loves her kids, and we love each other, but I don't love her kids and she doesn't love my kids, and the kids don't love us. And I call that the evil stepmom and evil stepdad problem. And depending upon the age difference, the kids could be waiting a long, long time for somebody to pass away before they're able to receive an inheritance. So here we're able to still use an AB arrangement where we're able to split the assets in between so that it's protected for a surviving spouse, and it's also protected for the decedent's children. You can have, I love you, honey, you get to have some income in principle, but when you pass away, I want my stuff to go down to my kids, or some variation thereof. So it's very important that we still use these AB splits for purposes of blended families. Again, it's not a tax-driven decision. This is more a family dynamic-driven decision. Very, very powerful, very, very important. So just some really quick math here. This is some lawyer math. So the new exemption right now is $11.5 million, a single exemption, so a single individual, assets at $10 million, life insurance at $3 million. This is just an example showing you that because the insurance is inclusive, my estate size is 13 million, not 10 million. And as a result, you take out 11.5, 40%. This is resulting in a $600,000 actual tax. But if you look at the assets are actually less than the exemption, right? So what's causing $600,000 of taxes is the life insurance policy. So thankfully, the government has given us some tools where we can start to reduce our state tax exposure. And this is why I kept on going back, life insurance, life insurance, life insurance, because we have a tool. It's called a life insurance trust. Uncle Sam acknowledges the very important need for life insurance, but we also want to make sure it's available and not being taken away. I don't want Uncle Sam being a 40% beneficiary of my insurance. I'm not paying a premium for Uncle Sam's benefit. I want that money there for the benefit of my family, for the benefit of buying out my business, for whatever the benefit is that you got it. I want to make sure it's there. So there's a tool called a life insurance trust that keeps the death benefit outside the taxable estate. And as I keep on saying, it may not be an issue for you now with 11.5 or $23 million. But if that exemption goes down as it's being proposed to $3.5 million, I can tell you that the majority of my clients here in California, a piece of property, a 401k plan, and a brokerage account, and maybe a business, $3.5 million exemption is nothing to what their overall net worth is. And then you add life insurance on top of that, all you're doing is just paying money into the federal government's benefit. So you got to create an irrevocable life insurance to protect and preserve those death benefits. And on top of that, the money that's inside this thing also gives us a liability shield. And if you remember from my previous conversation about asset protection, we're always worried about what personal assets do I have that are exposed to my creditors. And again, every state is different. The majority of the states protect cash value of life insurance, but places like here in California do not. And so if my clients get nailed in a lawsuit for whatever reason, car accident, whatever, I don't want the cash value that they're accumulating as part of their quasi-retirement financial planning needs to be taken away by a creditor. So now I'm looking at a life insurance trust for two purposes. I'm looking at it to minimize the estate tax exemptions, and I'm looking to protect the cash value from the claims of my clients' creditors. So again, we get a double dip here with this very, very powerful estate planning tool. There's also forms of gifting trusts. So here again, the way that you minimize your estate tax exemption is, I call it the three-legged stool. You use insurance, gifting, or insurance. Any one or all three of these. So we just talked about the use of insurance to pay taxes. You can use gifting, and there's various ways of gifting. There's straight gifting trust. There are forms of what are called grats. There are idiots. There are all kinds of ways of actually getting property out of your estate. And there are ways of doing it in a way that you don't just gift assets away and basically disinherit yourself. I got plenty of clients that want to give to their kids, but they still need the income that asset is producing. They're living on the income off that asset, but that asset is also appreciating and causing an estate tax problem. How do you marry that? So there are very specialized tools called idiots and grats and other forms of even charitable devices where we're able to get the asset out of the estate, let it grow out of the estate, completely asset protect it, all the while retaining an income stream back to us. Again, it's a little bit more of the advanced class, but I want to let you know that these tools are available, especially in the real property heavy owned estates. Also, on a recent development I wanted to share with you is retirement funds. I certainly can't talk because this ties into what's happening with the Secure Act. But one of the big things I always want to point out is this landmark case that came down in 2014 with the Supreme Court called Clark v. Rainmaker. And most of my clients, and you may even remember me talking about this in a previous discussion, that retirement plans are asset protected. Absent a federal creditor, the substantial majority of our 401k plans and IRA plans, again, state dependent, are going to be protected from our creditors because the government wants you, encouraging you to put money away for your retirement. And they want to provide protections over that. So the first time you get into a fender bender, the plaintiff's lawyer doesn't take your retirement away. If they take your retirement away, you're going to become a ward of the estate, when you no longer are able to work. So they want to make sure that those funds are protected. So they created these very powerful ERISA, Employee Retirement Income Security Act, anti-alienation and spendthrift provisions to protect your retirement plans. But when somebody inherits that retirement plan, it now loses that protection. And that was the holding of Clark v. Rainmaker. It's protected for your retirement. It's not protected from the claims of an inherited beneficiary. It's not their retirement plan. All the need to protect it for the retiree, not for the beneficiary. It's just a fancy bank account that has some deferred, tax deferral. So that was a big deal. And how do we now protect our inherited assets? We now have to turn to other devices such as an IRA inheritance trust, some type of trust to give us retirement protections. As I said, three large assets: a house, life insurance, and retirement. So if you got a 401k plan that's got $1 million in it and you pass away, that $1 million doesn't go part of your trust. It typically goes straight to your kids. Now, we may have done a bunch of other stuff to protect your kids and stuff from their creditors, but the retirement plan goes to them directly because the advisor said, let them stretch it, let it go to them, let them get the benefits of it. But all of a sudden now it's theirs. And because of Clark v. Raymaker, that is now subject to the claims of their creditors. We want to avoid that by continuing to protect the inherited IRAs by way of these IRA inheritance trusts. And we have to be aware because, as you all may know, there's a brand new thing called the Secure Act, which took what used to be a nice lifetime RMD distribution for the beneficiary's lifetime, now says it has to be distributed in 10 years. They call it the Secure Act. I'm not quite sure whose security. I think it's the federal government's security. It certainly isn't my Security Act. So definitely caution, taxes are ahead. So you've got to find some other device where we can protect those tools, hopefully beyond the scope of a 10-year time period. And also in the same vein, when it comes to retirement assets, and this is the crossover to the use of IRA-owned LLCs, we use IRA-owned LLCs for, of course, for asset protection reasons. We use it for alternate investment purposes, but I also use it as a protective tool for the inherited IRAs. So all of a sudden, my client inherits that $1 million 401k. It became an inherited IRA. They didn't use the inheritance trust. They lost that option. So instead, we're going to put it inside an IRA-owned LLC to give them now a level of protection that now Clark v. Raymaker took away from them. And the added benefit is that now they can self-direct that. They can invest in businesses, stocks and bonds. All of you out there that are heavily involved in real estate, you may have friends or family that's investing their retirement funds in investing their retirement funds in real estate. How are they doing it? They're doing it through a self-directed IRA. And then the only proper way to do it is within an LLC inside their IRA for liability and asset protection. Again, go see the other video I put together with the association about that. And so we create these IRA-owned LLCs, not only as a regular investment opportunity, but certainly as an inherited IRA protective option as well. And then just kind of wrapping things up here, we're talking about other invaders to the estates. We're always worried about asset protection, IRS regarding estate taxes, probate concerns, and now we have to worry about what about the beneficiaries' creditors? What about the beneficiaries' divorces? What about the beneficiaries' overbearing spouses? I work my whole life. I put a legacy together. I'm going to give it to my kids. I love my daughter. My son-in-law, as I said, not so much. I don't want my money that I gave to my daughter to wind up in the hands of my son-in-law. It's her separate property. I want to make sure that it's for her benefit. It won't become commingled with the marital assets. It won't become subject to my daughter's creditors if she has a lawsuit or a car accident, God forbid. I want it to be protected. So we create these protective trusts for the benefit of our beneficiaries, our kids. We have to use other devices for us, other forms of LLCs and corporations and limited partnerships, but we can use properly structured our everyday trust in every state in the union to create an asset protection vehicle for our kids from their creditors, their divorces, their overbearing spouses. If the children have disabilities, special needs issues, very important we put that in to protect and preserve those government benefits and not disqualify them by giving them $1 million. If the kids have drug or alcohol addictions or gambling problems, you don't want to give them money. You want financial guardianship over that. And of course, improper trustee arrangements as well. Okay, you want to make sure that you choose somebody who's the best person for the job. I always say that you don't want to get on an airplane from LAX and you're going over to Hong Kong and you're flying at 36,000 feet over the Pacific Ocean. And the guy comes out, the captain says, oh, by the way, everyone, this is my very first time looking at a cockpit, very first time I'm flying. And meantime, your family and all of your assets are inside that 747. You typically want the captain that's got many, 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 many hours of experience of flying that airplane back and forth. That's an experienced trustee. Putting your kids, putting your parents, putting your sister or brother as a trustee is great. They don't know the first darn thing about flying the 747. Maybe they can be an advisor to a professional trustee, but they shouldn't be the trustee without having appropriate background and experience. And of course, the kids themselves, you always have to worry about giving the money to the kids because they will wind up consuming it. I think the statistic is within a year, maybe 18 months, inheritances are completely consumed because of the complete mismanagement of the funds from the kids. And again, using the value of a professional trustee, again, experience and accountability. They use myself or other professional trustees simply because of commitment, longevity, especially with an institution. Wells Fargo or some other institution, probably not going to pass away. They may get gobbled up by a larger bank, but they themselves is not going to be they're not going to pass away. So the file could go from generation to generation and still stay within the same trust company for consistency purposes. The big reason here most people choose us, besides the experience and accountability, is objectivity, right? So you may have 2 or 3 kids. They all may be, maybe Uncle Bob likes kid number 1, not number kid 2 or 3. You got emotional and family history. When you have a professional, I have a job to do, right? Figure it out. I have to split and manage these assets accordingly. We're going to need to work this out. I have no emotional involvement with the children and or the assets. So that brings a lot of sanity to an administration for sure. We follow regulations. We have accountability as far as insurance policies and things like that. And I think most importantly, we understand the position. And in the last couple of minutes, I'm going to speed through this to kind of open it up for some Q&A, is charitable considerations. Here, as I always say, that no act of kindness, no matter how small, is ever wasted. That's a very good quote. And there are various ways of giving money strategically. Outright gifts, you put them in your estate plan, life insurance, retirement plans. But the one that's most appropriate, in my opinion, to property owners that have highly appreciated assets. You bought a property, has a very low basis, it naturally appreciated, and you got this huge equity corridor. If you sell it, you're going to take a bath in capital gain taxes. And yet it's not producing the income that you need for whatever reason. So the use of a charitable remainder trust really kind of helps to utilize that. And so what this is basically you create a special type of trust called a CRT, charitable remainder trust. It's a remainder because during your lifetime, you benefit from all the income, but then when you pass away, all the assets go to the nonprofit, the charitable remainder. But because you're partnering up with the charity, certain tax benefits apply to you. And one of the very first benefits is that when you contribute the asset into this charitable trust, well, the first thing you do is you get a charitable tax deduction. Just like you're giving to a charity, you get deducted on your income taxes, no different here. So you get a charitable deduction, which actually was money in the bank. And then you get to sell the asset, as I said, highly appreciated, but you pay no present capital gain tax. You sell it, capital gain tax deferred, not free. Capital gain tax deferred. It gets deferred over a long-term installment basis, but you've now produced an income tax machine, not reduced by capital gain tax, and it gets to grow inside this charitable environment, tax deferred, much the way that IRA money grows, tax deferred. So you put a piece of property inside there, you sell it. You got to be willing to sell it. If you don't want to sell it, not the proper tool for you. And then we typically would, if you're going to use a charitable remainder trust for like actually a $2 million asset, well, if the charity is going to be the remainder beneficiary, who's not the beneficiary? Your kids. So typically then we would use a life insurance policy to offset. You put $2 million in the CRT, you put $2 million to balance it out. That's what most people do. It's not a requirement. It could be more, it could be less, or it could be nothing. And as a result, when you pass away, you got the lifetime benefit of the income. When you pass away, the charity gets the remainder, and then your kids get the death benefit of what they would have gotten, but for the CRT. And the cool thing, how this pencils out real quick, is you start with a $2 million asset. You get a 10%, in this case, I'm illustrating a 10% deduction. So they get a $200,000 donor deduction. That applies on your current taxes and moves forward X number of, I think it's 5 years thereafter if you can't use it all first year. And this is the real power of it. You start off with a $2 million opening balance. Remember, it wasn't $2 million minus 20 or 30% of capital gain tax. The opening balance was $2 million. And I'm illustrating this at a 5% growth, 5% investment. It doesn't matter if it's income or growth, this is 5%. And this investment, 5%, because it's in a charitable environment, again, is growing tax deferred. So our first year back to my client is $218,000. That's year one. So that's a lot more than the $5,000, $6,000 a month they're getting on rent. And then they carry it over to the next year. They get 5% growth, 204. They carry it over 5% tax deferred, 192. If you go down the full distribution, and this number of distributions is based upon the IRS's survivorship schedules. They're going to take out basically 2.7 because of the time value of money tax deferred without having to take the initial capital gains hit. They're going to get more money than what they started with over time. But what's the catch? The remainder, the charitable remainder, if all of a sudden you pass away at year 10, well, this $1 million that's still inside the account doesn't go to your kids. That goes to the remainder beneficiary, any 501c3 organization of your choice. Susan B. Komen, it could be Wounded Warriors, Red Cross, it could be a religious organization, an educational organization. That's the charitable remainder. So it's a very, very powerful tool, way to give a great legacy. And so this is how it looks. Once again, put the money inside the trust, the asset in the trust, sell it, you get the deduction, you get the income during your lifetime. Sometimes you use it to supplement the cost of an insurance policy. You then pass away. The life insurance went from a policy now to death benefit. And then the charitable beneficiary gets whatever's left in the trust, and the kids get the life insurance policy. That's like a win-win-win. No capital gain, beneficial investments, large income deduction, income to you, and a large beneficiary, a large deduction, large contribution to the nonprofit, and then your kids ultimately get a income tax-free and estate tax-free distribution from an insurance policy if you use that direction. So finally, real quick, just to wrap it up, Alexandra, then we'll kind of come back online here, is the need for estate planning, update to reflect the new 2018 law, provide for survivorship and children as far as the traditional, also for blended families, okay? The families are changing and they're dynamic, and make sure that your plan reflects the latest and greatest options and protective options for your kids. Asset protection for kids' inheritance, huge. I see this as a lost opportunity all the time. Want to make sure that we have that there. Special needs children, if providing for your incapacity, very big, especially in this COVID environment. It's not incapacitated. It's not you're unable. Sometimes you're unwilling. Like I said, my dad is perfectly able of going to the bank. He's unwilling to go to the bank. So we're using the power of attorney in the case of unwilling, not necessarily unable. Make sure you have enough liquidity, so we're not fire selling our assets. Want to make sure we have enough liquidity to pay all our obligations. Charitable considerations, and just, I guess, one big takeaway. This stuff is not easy. I'm talking very fast. I'm just barely scratching the surface on what's available, but still you can see there's a lot of tools and techniques that we have regarding what's available for us in estate planning. Make sure you work with an estate planning professional. This is not family law. This is not criminal law. This is estate planning. It's complicated, and you want to work with someone that's familiar with this area. And lastly, I just want to say that people spend more time planning a 1-week vacation, right? Where are we going? Hotels, cash, airfare, driving, budgetaries, clear my email message before, email after. But yet when it comes to their estate plan, where it's everything they've ever worked for, including their minor children, they'll download a form off the internet, right? They'll go on to some online service that pays $200, or they'll get a lawyer in a box at a local big box office supply store. And it's everything that you got. And I can tell you from an administration point of view and a trustee's point of view, whatever's written on the 4 corners of that page, that's going to determine the ultimate outcome of your legacy for your kids, your surviving spouse, your multiple generations. Give it some time and give it some respect. It's not easy. Make sure that you work with a professional. So with that, I believe, Alexandra, you want to come back online and open it up for questions?
Yes, absolutely. Thank you so much for that. You were right. Very thorough.
Yes.
And I think, we could even use more, but we did get some questions already, and we can start with those.
Great. Thank you.
Let's see. Thank you guys for staying on a little longer today. I think it will be worth your time. So let me go ahead and pull up the questions here. Let's see what's going on. Alrighty. So, question here is, if a married person has an asset that has been kept separate, should the separate asset be put into the living trust?
Great question. Yeah. So many times people will have a mix of assets, and I'll just use California: community assets and separate property assets. The separate property assets can be because you brought it into the marriage. Maybe you have a premarital agreement, maybe a postmarital agreement, maybe you received something while you were married by gift, or and as a result, you have separate property assets. But you have a joint trust, husband and wife joint trust. There's typically a provision in the document that says that the characterization of the asset before it got put in remains the same. So if it was community before, it's community after. If it was separate property before, it's separate property after, meaning that you don't change the characterization, which is important because sometimes my clients get divorced and the asset comes out of the trust the same way that it went in the trust. So if it was separate property before, it goes into the joint trust, separate property, and it comes out as separate property. Now, where that gets a little messy is what they've promised each other, what they've told each other, their behaviors. So if you have separate property, it's always best to supplement that with some type of spousal property agreement, some type of transmutation agreement, someplace that says, and both spouses agree, this is my separate property. That's a whole different conversation. But to answer the question, Alexandra, simply putting a separate property asset into a joint trust typically will not transmute that into community property or joint property.
Good point. And also,
Very
for
important in
those,
blended family arrangements. Yeah.
oh,
So, yeah.
absolutely, that
Yeah.
makes sense.
Yeah.
For those of you that are also on, I forgot to mention, I did put in the chat a link to schedule a free estate planning assessment with Brad
Yeah.
or someone from his team. So
Thank you.
click on that link if you want to do it. I'm going to also send you an email tomorrow with the recording and the slides, Brad's contact info, that link to schedule an assessment. So you guys don't have to worry if you can't get it right now.
Right.
I'll give it to you guys tomorrow.
Thank you.
All right. So from Richard, is the estate tax based on net worth or gross value of the estate?
It's net. Yes. So I did mention gross, and that's typically how probate is determined. And I'm really only speaking from California, but I've seen this in many states as well. Probate, the fees that lawyers charge in probate is based upon the gross estate. That's the appraised fair market value. But estate taxes are based upon the net estate. Okay. So you can have a gross estate of $1 million, but a net estate of only $10,000, right? Because you got $990,000 of debt.
Yeah.
Right?
Yeah.
So I, the lawyer, get paid on the million. Government gets paid on the 10. So
That's a good differentiation.
it's a good deal.
Yeah. So here's another one here. This comes to whether it's a good idea to get your trust reviewed by another attorney besides the one that originally helped you write it.
Well, you know what? That's in my space, there certainly is a level of competency, and there should be a core competency that most planners have, and it comes like with anything. It comes with time and experience and scars. It also comes down to personality, right? It's one of the things that who do you like to work with? If you have a feeling that your attorney isn't competent, or maybe they didn't discuss certain things with you, then for sure, it's always good to get a second opinion on things. But if you're comfortable working with somebody and they are the family lawyer that's doing multiple generations, I always say we're doing upstream planning and downstream planning, my parents and my kids, then typically it's based upon relationships. Who do you like working with? Who do you want to air your dirty laundry with? Because we need to know that stuff about the kids and this and that. So I would just say that if you do have it reviewed by somebody else, which is perfectly fine, just please respect that individual's professional time. I have no problem with people using me as a second opinion, but you want to make sure that you're respecting someone's time. So if you are going to have another person look at it, at least if you're happy with that analysis, at least be willing to go forward with that individual, right? It's just a matter of respecting people's professional time. So I look at it as a relationship thing and a core competency thing, okay, as to help you make that decision.
Absolutely. And I think this specific type of law is different in that it does involve a lot of personal kind of interaction and knowledge of that, person's relationships
you
and whatnot.
learn a lot of interesting stories about family dynamics and doing what I'm doing. And I can tell you that relationships are complicated and families are complicated, and we do our best. It's never perfect, but it's certainly better than the alternative.
Hmm. And so I'm going to go to another question here, which I
Yeah.
thought was interesting. So for someone who's single
Hmm.
and has 3 rental units,
Hmm.
saying here that they don't want to get a trust, is the best solution to put my 2 children on the deed so that it doesn't go to probate?
Yep, that's definitely an option. As I mentioned before, joint tenancy works. There's no question about that. The challenge, though, by putting the 3 kids on there, or you and the 2 kids, is that they each have a third, a third, a third. So we already talked about some potential gift tax issues. By putting the kids on, you may be giving them a 1/3 gift, which may result in some gift tax issues. The second thing is you have to worry about the kids' creditors, right? So all of a sudden the kids have a car accident, you could lose your property. You're also exposing each of the kids to the landlord tenant-based liability. They're now an owner, right? Joint and several liability. Um, the answer to the question is yes, you could use joint tenancy as a way of transferring the property between the owners through that right of survivorship. But my professional advice would be no. It should be in an LLC, and that LLC should in turn be inside the trust. There is a right way to do it. This is the cans versus the shoulds. Can you? Yes. Should you? No.
Got it. Okay. Well, a similar line of thought here. So someone's asking, okay, they have a daughter who owns a fourplex, but then she got married.
Mhm.
How is that property treated without a trust?
Right. So it goes back to the general statements of premarital assets and then marital assets. And it depends upon the states, community property states versus common law states. So in all situations, whatever you bring into the marriage, typically it's going to have that separate property component. Now the question is, well, now that you got married, right? Once you say I do, well, what happened then? And that depends upon community property or common law states. There may be a partial spousal buy-in, or there may not be. So just because someone gets married doesn't mean that the assets automatically become part of the marital assets. It's really dependent on state law. So without more information, I really can't answer that question, but it doesn't just happen automatically. If the property is kept separate and the accounting is kept separate and the spouse is not on the banking and doesn't really have, then there's a strong likelihood that it would stay separate, absent something like a community property state where there could be some additional spousal buy-ins. And this is why premarital agreements or postmarital agreements are very important to kind of clarify these issues.
Yeah, similarly, there's another question too about if you are married and you have separate individual trusts
Yeah.
and you get a property, which trust should it be placed in?
Right. So that goes,
So,
and so again, that goes back to, a misconception is that you can only have one trust. So I'm glad that this individual is talking about multiple trusts. You can have an unlimited number of trusts. One will, unlimited number of trusts. So the trust, and so it can like a blended family, for example, Alexandra. I call it the his, hers, and ours. So I have separate property, my wife has separate property, and then there's property that we're accumulating together as a marital unit. So here, I would put my separate property in my separate property trust for my kids. She would put hers, and for her kids, maybe we have some income, but we bought a house together. How do we deal with that? So depending upon the nature of the asset, how it's classified, depending upon the nature of the relationship, you could put that property in his trust, in her trust, in our trust, right? It depends on what the client's ultimate objectives are.
what's the most trust you've ever seen?
Probably I've done it to my own clients. I, I could easily think of several clients I have, 7, 8 trusts.
Oh,
I,
wow.
it's residence trusts, life insurance trusts, asset
Yeah.
protection trusts, charitable trusts, successionary idiot trusts. I mean, it's not that we just sell trusts because I'm looking to put my kids through college. It's typically the client's objectives. They have a mix of assets and objectives with those assets where we have the proper tool, right? We have certain tools that apply to certain assets. The question is, does the advisor spot that? Do you have enough knowledge to be able to say, hey, listen, what about using this? Let me share with you what planning tools are available for this particular type of asset. And the client buys into it, they buy into it. And they typically buy into it because the benefit they're getting from that far outweighs the cost or administrative inconvenience of implementing that. And we're talking about hundreds of thousands, if not millions of dollars of tax savings. It's worth it. And that's how you come up with all these trusts. It's all based upon need.
Mm. That's a good point. And then also as well, I see a couple questions coming in about LLCs,
Yep. Mm-hmm.
which we've talked about before, but
Sure, no problem.
we have somebody asking, when does it make sense to convert someone else to an LLC? The other person is also saying, if my LLC holds my property and manages my property, is that a problem for estate planning?
Mm-hmm. Okay, let's talk. The second one is easier. I'm not quite sure I get the first question, but the second question is, an LLC is the proper place for your rental properties. So start with that. It could be a limited partnership or it could be an LLC. That's the proper place. And if it's an LLC, you would manage it. You're running the day in and day out operations. If you have a general partnership as part of your limited partner, then the GP runs the day in and day out. That's the proper place. Now, what do you do with the LLC? That goes inside your family trust. The trust is not an asset protection tool. Let me say that again. Your family trust is not an asset protection tool. So you still need the LLCs and the limited partnerships and the corporations. You still need that. But for probate avoidance and for testamentary distribution purposes, those assets need to be in the trust. The trust is a wealth transfer tool, not an asset protection tool. So she's right. Having the asset in an LLC, that she's the manager, perfect. Now, where does that LLC belong? That belongs inside your shoebox. That belongs in your trust. All right. What was that first question again?
So the other question I think is something we've answered before, which is just when should you convert to an LLC? So if I'm an individual owner of a rental property, and it seems to be like there's really as soon as you get a rental property.
Yesterday.
It's not really a matter of like how many or what size.
No. Right.
So
It's all a matter of all a matter of liability exposure. If you have a property in your name, financial suicide. Period. The quicker and sooner you can get that property out of your name and into an LLC, it's not giving up control, but you now have limited liability. Again, it goes back to what I just said. You have the benefits afforded by the structure, the limited liability, and the asset protection are greater than the setup fee and the annual recurring cost. If that's the case, if someone is able to articulate and explain to you the benefits of the structure, 9 times out of 10, clients are, how quickly can I get this thing set up? Because it's only, and especially, we talked about this last time in COVID, I can't imagine what type of litigation tidal wave is going to be coming from our tenants and from our employees and just from people in general, because they're out of work, they're desperate, and they're looking to people to go after predatorily.
So then another related question, would you recommend having a separate LLC for maybe a business that is not related to the rental properties and then having a different one for the rental properties?
Yes. And again, that's just a matter of taking a look at a feasibility. You have to be conscious of cost. You have to take a look at the client's tolerance for complexity as far as businesses and owning different entities. Maybe you have a CFO that can kind of help with that, or CPA. Again, that's all a big depends, but the answer is yes. Assuming it's financially feasible, one LLC per asset is best, but it doesn't mean that you can't consolidate. It's just that you want to take a look at it. That's more what I call the art of what I do, not the science. The science of what I do is LLC. Okay, done. Now the question is to your question: how many? Where do you set them up? How is it designed? That's more the art of what I do as an asset protection attorney.
So another question that we addressed on the last webinar we had actually with Steve, which is, does having an LLC make you susceptible to the California statewide rent control? And the answer to that, as far as I remember from Steve, is that no, unless the LLC is held by a corporation.
I'm going to defer to Steve. I don't know the answer to that one. Yeah.
So we'll defer that one to Steve.
Right.
But it's a good question. We did do a whole hour on it, more than an hour, last like a few weeks ago.
Yeah.
So
Yeah.
yeah, I'll share that with you guys. Also, I want to just go over, there's a lot of questions, but I think one of the questions that I thought we could touch on a little bit is that that exemption, the $11.58
Yeah.
million.
Yep.
This person is 77 years old, and she's asking, is it wise to give adult children an appreciated real estate now while the exemption is $11.5 million and while there's still a stepped up basis?
Okay. So the answer to the question is no, she should not give it to the kids. And this is the reason why. And this is going to sound very, very harsh. I don't intend it to be that way. But it's actually, for highly appreciated assets, it's actually better to die owning them than to give it away during your lifetime. And it all has to do with a thing called the step up in tax basis. If you were to take the highly appreciated asset and you give it to your kids, the donee, that is the children, take the donor's basis. So if you have a very low basis, your kids, the recipients of that gift, will take that lower basis. And now when they turn around and sell it, they're going to suffer that huge capital gain tax at whatever state they're resident in. Here in California, cumulatively between state and feds, about 35%. But if mom or dad passes away owning that, and it's within your $11.58 million, well, you didn't pay any estate tax because it's within that dollar amount. And now they get a full step up in basis, which means the low basis gets reset to the date of death value. Now the children inherit at $2 million. The basis is $2 million. They sell it date of death at $2 million. 2 million minus 2 million, zero capital gain tax. So there's a huge difference between assets that are appreciated and not appreciated as far as gifting. Now we do go in, if people have assets that are pushing up against that higher exemption, well, you may want to pick and choose. I want to get some assets out. Well, which ones do you get out? Maybe you want to get the ones out that don't have so much appreciation. Maybe the newly acquired assets, right? So again, that goes back to basically a gift, an estate gift planning feasibility study, right? Take a look at that. But the quick answer for what the lady is asking is that the kids are better off inheriting, even though it's still within the 11 point. Because even at 20% capital gain tax, it's still less than 40% estate tax, right? So you got to balance. You got to balance it out.
I suppose if it starts to approach 2025, which is when this will expire,
or sooner, depending upon the next administration.
Right. So if it is sooner, then at that point you could also determine if you should be taking out some of those assets.
Yes, and believe me, this will be something that will be in every financial publication and news program. You'll know about it, right? It's not something that Congress is gonna sneak by us.
Yes. Yeah. Okay. Well, we're approaching 12:30. We still have a lot of questions. I think, they're really good questions. So I'm definitely going to send them to you, Brad, to follow up on.
Sure. Thank you.
And then, of course, again, one more time, we are going to give everyone the recording. I still have the link in the chat if you do want to schedule something with Brad. And with that being said, Brad, thank you so much for coming on. This is fantastic. So much information.
I apologize for the rapid fire, but I wanted to get a good spectrum of information to the audience, and hopefully that's why we had that time. Any questions on the materials, feel free to